I do apologize that we've kept you waiting for this long. You've been here before. You know how JSC processes work. We more often than
CJ,
not.
I'm having a little bit of difficulty hearing you.
Oh, I was just apologizing for keeping you waiting. We are running behind schedule.
No, thanks, CJ.
Thank
Thanks.
you. All right, are you ready to start?
Is everyone?
May we start?
I'm ready to.
All right. You are no stranger to us. You've been here before, so we will try to keep this interview as short as possible. But I do need to reintroduce you to those who may not have watched your previous interview. You hold 5 degrees,
Yes.
to which are 3 directly related to your field of work. You did a BCom and BA honors in industrial sociology at Wits, followed by an MA
Yes.
in sociology of labor studies at the University of Warwick in the
Yes,
UK.
that's correct.
And that one you did on the British Council Scholarship, not so?
Yes.
Okay. How did one get chosen for that scholarship? Did it have anything to do with your merit?
Such a long time ago, but at that time, I don't think I was the only one. There was quite a lot of students, South Africans, who got British Council scholarships. There were also US aid scholarships that were available at the time, if I remember. I chose to go to Britain. I was invited by one of my lecturers or somebody to apply. And I did, and it worked.
But then your competence would have had something to do with it. Not everyone was. It was not just thrown at everyone who wanted it.
Obviously, yes. Obviously, you had to meet the criteria.
Yes.
So yes.
Then you did an LLM in labor law at Wits again.
Yes, before I did the LLB.
I wanted to ask about that. Then thereafter you did an LLB. How did it work?
It was strange because I had already been a lecturer in sociology at Wits at the time, so I knew some of those people. I then applied for the LLM, got in, worked with the LLM. I worked with Edwin Cameron. He was my supervisor, and the dean at the time was Carol Lewis. Both of whom were judges. You'll be aware, and they said, "Yeah, you can." Carol Lewis said, "Yes, you can do both. Why not?" And so we did it, and we ended up doing it.
All right. Speaking about your tenure as a lecturer, it was at Wits.
Yes.
You taught medical. Well, you tutored in medical sociology.
I tutored in medical, yes.
And was a junior lecturer. You did well as a tutor, so they promoted you. You also had a brief stint in the labor field. Did you work for a trade union, Kausa?
Yes, commercial catering and allied workers union.
But that was for.
They still exist. They call South African Commercial Catering.
Oh, all right.
And they still operate in the Pick and Pays and the Woolworths and.
All right. Then from that experience followed your work at IMSA as a mediator, perpetrator, senior commissioner at the CCMA, and then you went to the bar in 1996.
Correct.
And took silk in 2010.
Yes, correct.
In the same year, you started acting as a judge.
Correct.
In Johannesburg. And you were appointed. You acted for a short stint?
Correct.
Just 1 month, and then boom, in May 2012, you got your permanent appointment.
Correct.
Okay. You've acted as a judge of appeal at the Competition Appeal Court. You've had a number of stints there. and you also acted at the SCA
Yes.
in the last term of 2024 until the second term
Yes.
of 2025. So it's 3 terms?
2 terms.
Or just 2? Oh yeah, December 2024 to May 2025. It's 2 terms. So you do have a fair amount of experience at the appellate court.
I do, yes. And if you count appeals in 3 benches as appellate court, then of course
Yeah.
it's a bit more, yes.
Have you written any judgments at the CAC?
Yes, I did.
How many?
I've written 3. I was scribed for 4, but 1 collapsed on the morning.
All right. And at the SCA in those 2 terms?
Yes, I've written 3 judgments.
3. Okay. You list a host of involvements in quasi judicial roles. I'm not going to go into those, but more interesting for me is the fact that in the midst of everything you do, you found time to publish a book, a social contract. But that was some time before you became a judge.
Yes. It was an interesting topic at the time. It was an important topic at the time. It was pre-1996. And a lot of the debates that were going on at that stage was what should be the approach, what approach should our country adopt? And the organizations I had contact with and was involved in was concerned with that topic. So I sat down and wrote my thoughts, did some research and wrote my thoughts.
Yeah. And you have written an article in that field and a couple more in labor law.
Yes. I've also written, I think, an article on sociology.
Let's see. I did promise that the interview would be fairly short. Now I'm trying to see if I can live
Really
up
nice
to
if
that
this one
promise.
is short.
Oops. How old are you now?
66.
66. So you still have a good few more years to serve if you are elevated to that court.
To go, yes.
All right. I will let you go and hand over to President Mulemela, whose court you want to join, and the rest of the commissioners.
Thank you, CJ.
Good afternoon, Judge Vally.
Good afternoon. I'm having a bit of difficulty hearing, so I'm appreciating.
Oh yeah, the acoustics are not particularly good here.
Good afternoon, President Mulemela.
Yes, how are you?
I'm well, thank you.
All right. You had an opportunity to act as a justice of the Supreme Court of Appeal for 2 terms.
Yes.
How was the transition from being a judge of the High Court to being a justice of the Supreme Court?
The transition, I wouldn't say was too difficult. But the experience was very interesting and very valuable. But the transition, I didn't have too much difficulty. I don't know why, but it came quite natural. It was quite easy. For a start, let's talk of the social. I thought, I'm going to have difficulties living in Bloemfontein. I was pleasantly surprised, very pleasantly surprised. It's nowhere near as bad as I thought. In fact, it was very good.
I'm glad to hear that.
Bloemfontein is quite good. I mean, there's a lot going for you in Bloemfontein. And I found
that I fully agree with you.
You fully agree with me.
So, you informed sorry, did I cut you? Oh, did you still want to add?
No, I had nothing to say.
Okay. All right. Okay, so you told the Chief Justice you wrote 3 judgments at the SCA. What was the turnaround time?
Turnaround time. All my judgments were written as before I left. In other words, before the term was over. All my judgments. When I was previously interviewed, I do recall very clearly the Chief Justice asking me about work pace and telling me that there was a convention that you must finish your judgments in the term in which you sit. And I thought that that convention still applied, so I worked sure I wrote all my judgments before I left, all of them. Before we packed my bags, they were either out to the rest of the panel, or at least they were out to a researcher who then sent it out, brought it back in a day or two or three. 3 days later, it had to go.
Yes, I do remember that the day before the term, you came to me and you said exactly what you have just said now, that they are in a stage of being finalized. So I'm happy to hear that they were finalized soon thereafter. So you have no reserved judgments.
I do. There
From
is
the
a
SCA?
reserved judgment. No, there is a reserved judgment.
Okay.
No, there is. What has happened there, after I've written my judgment, then other panel members had looked at it. Another panel member decided to write a different judgment. That took some time. That has come out. But a third judge now has decided that she wants to write another judgment. So we're waiting for a third judgment. So, and I don't know, and the fourth judge, I don't know what's going to happen there. So, yeah, it was an interesting question.
Yes, but yours was...
And the panel's working through it. And the fact that we have so many judgments would make it a very interesting conference and a very interesting. Whether we end up with only one judgment or not, I don't know. It would be nice if we do, but we're working on it as a team. So it's not only up to me.
Yes, I understand the process, but your own judgment, you circulated it timelessly.
I've circulated it a long time.
Thank you. Thank you very much, Judge Vally. Thank you, CJ.
Thank you, President. Commissioner Matolo Dlebo.
Thank you, Chief Justice. Good afternoon, Judge Vally.
Good afternoon.
I'm here.
I'm here.
Yeah.
Sorry, thank you.
I think mine is not a question, but just a comment. I just want to hear your opinion regarding, you are an experienced mediator, and remember when we were still at IMSA, you used to coach us on mediation.
I used to?
Coach us on mediation at IMSA.
Thank you.
Yes, but what I wanted to find out, because there's this court, now there's a directive that parties must go for mediation.
Yes.
Have you, and mediation being a voluntary process, you know,
yes.
Do you think it's working in an environment, or do you think it has a potential of delaying matters going to court? I just wanted your opinion.
I think it's an exceptionally good question. I don't think, remember when we worked at IMSA, mediation was voluntary. We chose it and we decided that we want mediation. And it came out of my experience as a trade unionist. We were the ones who pushed for it in the workplace. Forcing mediation on the parties as is happening here, I understand the logic. The logic is that a lot of people are settling at the door of court, particularly in the very busy road accident fund cases that we receive in our court, the very busy court. I've seen a lot of problems in the last term, a lot of complaints by parties saying this is simply just another route for us to follow, but we're going to still come back. And I've got a lot of applications in an unopposed court compelling a party to come to mediation because that party is delaying and not willing to comply with the practice directive. It's very, very young at this stage. How it's going to pan out, I don't know. I hope that it will work. If it works, it's to the benefit of litigants, it's to the benefit of the court. We are, I must say, inundated in that court. And whether this was an act of desperation, I don't know. I don't think so. But we need to do something. We can't have a situation, quite honestly, we can't have a situation where litigants must wait 5 to 7 years before they can get a trial date. By that stage, things can be very difficult. So yes, I agree with you. The experience is a bit mixed at the moment. It's too young to say whether it will last. There is a problem with financing of the mediation. When we did it in IMSA, remember there was a lot of funds coming from overseas, and we could use a lot of those funds for mediation. So a lot of unions, like my union, was getting money to assist us in these things, and we used it. We paid for mediators and things. IMSA also got money like that. It's a bit more different now. What it costs, etc., I don't know. So to answer your question, I would hope it works, but I see problems already arising. And hopefully we'll iron them out in time.
Thank you, CJ.
Thank you very much, CJ. Good afternoon, Justice Vally.
Good afternoon, Commissioner.
Okay. No, thank you very much. I took interest as well in your work more around your publications and also your book that shows more strength in terms of industrial sociology.
Yes.
In looking at today's work and your background in terms of union work and all that, how do you think we should be able to help the country in balancing the interest of investment versus participatory democracy, especially taking your strength or your area of work, such as on mediation, in dealing with labor movements in the country?
Thank you for that question. It's a very interesting question. And it's not easy for a judge to comment on political issues and or other social issues, especially when some of them may come up before me in one form or another. But I do believe that my strength and my experience as a mediator has taught me that there's a lot of room for dealing with some of the conflicts we find, particularly with regard to demands by the investors and the demands of the populace and demands on the country as a whole to attend to some of our very deep social problems. And they sometimes do come into conflict with each other. And I think through mediation we'll be able to, hopefully can resolve them. I know we have a body that was working through that. It's called NEDLAC, if I'm right. And it's supposed to be working through that problem. From the very beginning, that was our intention, those ideas. And I'm hoping they work. They sort of, I'm led to believe that they have done excellent work and they have managed to resolve many difficult issues over time. So yes, and in fact, I'm hoping that that benefit can seep through every other area. In fact, right now we have a government of national unity. I'm sure they're going to benefit from the ideas, the learnings, the experiences that comes out of that process.
Thanks a lot. I don't think it's political, Judge Vally.
I'll
more around
I'll agree with you.
The role, because I do believe that the judge and the courts do have a role to contribute towards socio-economic development in the country.
I fully agree with that.
And therefore, we all have to make sure that all that sharing and taking that responsibility. So I thought I should just give you assurance that I'm not coming from a political...
No. And I misunderstood your question, but I certainly agree with everything you say. And I certainly take an approach that we must, as courts, not remain aloof. We must not remain in an ivory tower. We must understand the difficulties and sufferings, and we must be sensitive to them, and we must bring it into our work. And I believe I have definitely done that. That I have no doubt about.
Thank you.
Commissioner Mangena, followed by Marumakhai.
Thank you, Chief Justice. I'm here.
Sorry.
On your left.
Thank you. Thank you.
Good afternoon, Justice.
Good afternoon, Commissioner.
Yes, I wanted to commend you for the judgment that you wrote on Resilient Rock versus Voltex.
Oh, yes.
The judgment that dealt with Section 3475 of the Companies Act, the winding
Yes.
up. Whether to orders can coexist.
Yes.
A final order while there is a provisional order pending. And that judgment provided clarity that it is not possible or competent to have two liquidation orders coexisting at the same time. But thank you very much. With regard to the question that I have for you, you have remarked that there is a judgment that's pending where other judges have indicated their desire to write their separate judgments after you have written yours and you are describing that judgment. My question to you is, since you are an acting judge there, are you of the view, or have you experienced intellectual bullying in the SCA?
Intellectual bullying.
Yeah. Did you at any stage feel like you are being undermined because of where you come from and the depth of your intellectual ability to deliver judgments and the understanding of the law?
I wouldn't call bullying, but we did have some robust discussions in conferences. We've had robust discussions, and people have to justify the positions they take. And I found that quite challenging. I found the way they work slightly different from what I was used to. And yes, I found it very exciting in that sense. But bullied, no, I don't think so. It will be a bit difficult. I think we are all we're all intellectuals that respected each other. And I don't think anyone there would be able to say to me or me to say to anyone else that you don't know what you're talking about or you were. I understand that may have been a practice before. I don't know about it. I wasn't there. But no, I don't find intellectual bullying. I didn't. But some people may have found it difficult. I can't speak for their experiences. But not my experience wasn't that.
Thank you, Judge.
Thank
you, CJ.
Prof?
Thank you, CJ. Good afternoon, Judge Vally.
Good afternoon. At least I can see you quickly. I'm looking around for everyone.
No, thank you very much. I'm in a process of trying to establish whether the judges who have ambition to serve this country at the Supreme Court of Appeal, whether they are looking at the rules, they are thinking about the rules, and some of the legislative provisions that make that code work. And my question is based on what I've just said now. Last year, there was an amendment to the Superior Court Act, and in particular Section 17(2)(f) that deals with the reconsideration of decisions to dismiss leave to appeal in the Supreme Court of Appeal. I'm not sure if you are aware of that and the changes that were brought by those amendments. If you are, can you prefer some words on those changes?
Well, Section 17(2)(f) was the subject of a lengthy discussion by the judges of the Supreme Court of Appeal, and I was privileged to be part of that discussion. And I was also in a judgment in a case where 17(2)(f) was considered. And so, yes, I know about the issues. I know about the debates around it. I'm aware of the debate, and I'm aware of how the judges are busy dealing with that issue.
I think the debates are important,
Sure.
and one cannot trivialize them. But I think my question is more on what legislatively took place, because there was a particular test that was used for somebody to ask for reconsideration by the president of that court. And last year we saw a change in the test, and that's what I'm trying to probe, whether you are aware of the changes in the legislation with respect to that particular provision.
Yes. if you're referring to that on exceptional circumstances position, that the president may on exceptional circumstances call for reconsideration, they made it a little bit more difficult, if I'm correct. But we do get a lot of those applications that still say they have met the test, they've met the threshold. And yes, it is difficult. You must bear in mind that the legislature is trying to work through a problem where everybody by this stage has brought another application for leave to appeal, having failed at the first court, having failed by the two bench in the Supreme Court of Appeal, and now brought the third one. And the legislatures had to bring some sort of control and order in there. So I'm aware of that. And I think the legislation brought something good by asking for it to be on exceptional circumstances. But how it's going to fully pan out, I can't say in time. Because as I said to you, there's been robust discussions about it.
No, thank you very much. I will leave it there, but I think it might benefit you to look at what was done, because originally the test was exceptional circumstances, and that particular test has been revised to some extent. But in your time, you should be able to look at it. Thank you very much, CJ.
Commissioner
Thank
Hassan?
you for that. Thank you for that advice.
Thank you, CJ. Commissioner Hassan over here. Judge Vally, in your own jurisprudence, you've wrestled quite a bit with the tension between transparency, freedom, and the harm that speech could cause. Particularly in the SANEF versus the Minister of State Security case in 2019, you wrote that transparency is the lifeblood of democracy and secrecy is its poison. That's at paragraph 67. And you actually struck down provisions that criminalized publications about national key points. And those are quite powerful affirmations of an open democracy. But we're now in an era of algorithmic amplification, disinformation, hate-driven online, not only speech, but mobilization. And we're seeing this not only in South Africa, but the world over. So my first question is around your thoughts on how courts could or should refine the constitutional test under Section 16 of the Bill of Rights to ensure that freedom of expression continues to protect that robust democratic discussion and debate, while also guarding against speech that's dehumanizing, insightful, and endangering different interest groups. Thank you.
The issue is going to be alive for some time. Hate speech has unfortunately become quite prevalent the world over. At the same time, one cannot deny that there's also been a move to silence voices that one doesn't agree with. In Britain, they're struggling with this issue very strongly. They've prohibited an organization, and anyone who's in support of that organization is now finding themselves on the wrong side of the law. So it's going to be an issue with us for a long, long time. There is a lot of hate speech out there. There's a lot of painful speech. And I genuinely believe that speech matters, words matter. I genuinely believe that words matter, and they can cause significant harm. So yes, we're going to have to be careful about just saying we'll allow everyone to say whatever they feel like saying. We can't. We don't in this country anyway. We certainly don't. We don't allow speech. A lot of people have gone to prison for using, not a lot, but at least some people have gone to prison for using hate speech. We come from a history where there's been derogatory language used to describe certain people. We can't tolerate that. So while I on the one hand say, yes, it is the lifeblood, as I think what you quoted, it's the lifeblood of a democracy, I'm not naive enough to say that you can say what you feel like saying. I will never allow that. I will never tolerate that. I will silence it quickly, wherever I can, whenever I can. And if I have to do it while I'm on the bench, I'll do it. I have no fear or favor in that regard. And I have a position. I don't believe in absolute free speech. I don't. There is no such a thing. There can be no such a thing. because that causes so much harm. You can't. And I don't think any sensible democracy or sensible society can follow that rule.
So let me then follow with this, Judge Vally. Do you think or believe that our current jurisprudence, particularly on bona fide political expression and the harm principle, is it still fit for purpose in this digital age, or do you think it requires some further development or refining at the appellate level?
Do you know, Commissioner, is it Hassan? Do you know, Commissioner Hassan, we're living through a time where there's lots of changes taking place. And if you're referring to what's happening through this AI processes, you are. I see you nodding your head.
Well, it's a combination. It's AI. It's also been the fake news that really disseminates in the country. We were recently victims of an international, I would say, fake news sort of attack on the white genocide, et cetera, et cetera. So it's all encompassing. And I just worry whether our jurisprudence is moving as fast as it should to not only protect the state, but more importantly, protect our people.
Commissioner Hassan, it's not an issue judges or courts are going to be able to resolve on their own. There's going to have to be legislative intervention. And all the parliamentarians sitting here will have to look at the situation carefully. And parliamentarians may have to look at what they want to do. Judiciary cannot solve all our problems and will not solve all our problems. We must understand that. That's why we have three arms of government. And the legislature have a limited role, an important role, and a special role to play. And the judiciary have a separate role to play. But together, we will certainly be able to address this problem of hate speech, of false allegations, and they're harmful, they're very harmful. The one you just mentioned really harmed us. And I'm not naive about that. And I won't allow speech like if somebody came and they brought an application, an interdict to say that, then I will explain why I would grant an interdict on something like that. I wouldn't have too much difficulty when I see it harm. So, but it's not an issue. I genuinely don't believe it's an issue that courts are going to resolve by themselves. There's no way courts are going to be able to do that. There is legislation in place. Courts will apply that. Courts will probably develop the law. Will have to develop the law on some of that. But that's as far as courts can go. Legislature must then take over. Or in fact, should already start taking over. But I don't know. I can't take it further than that.
Okay. All right. Just two aspects from me, Judge Vally.
Sorry, thank you.
In front of you. I had hoped that the members of the professions would raise them with you. Maybe they were raised and I missed it. You'll tell me if I did. The GCB deals at length with the judgments, the 6 judgments you have listed in your questionnaire, which were overturned by the SCA, and they do a thorough analysis of your reasoning and so on. But at the end of it all, they return an assessment that your judgments are generally well-reasoned, and they extol your independent mindedness. Then they deal with the negative comments that had been made against you for your previous candidature for another position, and they dismiss those. They say those views are not generally held by the relevant people. But then there is one aspect they say at the end of their commentary, which I find a bit worrisome. They point out that you have a knack of sometimes disregarding precedent, which they say, and one would be inclined to agree with that failure to follow precedent may be interpreted by the public as a disregard for the rule of law. Are there any judgments of yours which have disregarded precedent, and what do you think of the authority of the doctrine of precedent?
Oh, certainly, stare decisis is important for the principle of the rule of law. Absolutely. It brings certainty, and certainty is important for litigants, it's important for courts. So without doubt, stare decisis has stood the test of time and should continue to be applied. So there's no debate about that. The allegation or the criticism that I didn't follow precedent, it's a little bit more complicated than that. They're referring to one particular, if they're referring to the one particular judgment I wrote with regard to contract, in which I believed that the Constitutional Court had moved in the direction towards reasonableness, fairness, but most important of all, good faith. And I then applied it, and I wrote a judgment, a minority judgment on that, in which I said, I'm following Constitutional Court principles. Since then, another Constitutional Court judgment came out. It's the famous one called Biedeka, and it has clarified the situation. There was a division there. My position was supported by the minority judgment of Froneman J, supported by Madlanga J, and then there was another minority judgment by Victor J, which took the same position. But I recognize that what the judgment that criticized me said was correct, and that was that I had assumed, and I had followed the approach that good faith can be a self-standing approach in principle, and Biedeka has made it quite clear that that's not correct. So I've learned from that. I've learned from that criticism. I understood the Concord to be going the other way, but Biedeka said it didn't. Now that came after me. But to say that I just disregard it because I don't like it, or I don't like the outcome because I don't think it's just, I don't think that's correct. I've many times followed precedent which in my view might resulted in not the kind of justice I would have liked, but that's the law. There's nothing I can do about that.
Many times or all the times?
Oh, I think all times. I follow all the times. In that position I took there, I believed that that was our law based on Constitutional Court judgments of, in particular, Parkhazen, Everfresh. There was a few of them, Botha versus Rich. There was a few of them that came out. But there was a tension, and I noticed that tension between a Supreme Court of Appeal judgment called Bredenkamp and those cases. And I deal with that in my judgment. And there was also other Supreme Court of Appeal judgments called Brisley versus Trotsky. There were so many of them.
Yeah.
Afrox Healthcare, I think, was another one. There were so many of them. And I went through all of them. One thing I do, Chief Justice, is I don't just pick things out of the sky and out of my head. I do my research, and I do it thoroughly.
And you do accept that you are bound by
and
precedent.
I am bound by precedent.
Okay.
I will definitely believe I'm bound by precedent.
That is
Whether I like the precedent or not is irrelevant.
Indeed.
Indeed, it's irrelevant. If I want to change it, I must be sitting in the right court, and that's where I must be making my point. If I'm not, I'm bound by what they say.
All right. Well, that's as unequivocal as I can't ask for more.
Thank you.
Then just one last issue raised by, is it the BLA? I think it's the BLA, which says those who practice in Gauteng hold a view that he does not have a good work ethic and often refuses to certify matters trial ready for what they suspect is an inclination to do as less work as possible. Do you have anything to say about that?
There's no truth to that.
But
I do take a hard line on certifications. But I think there's a there's probably going to be a misunderstanding here. Let's understand what certification is. In the Gauteng High Court, at one stage, we set up what was called a certification court because everybody was coming to court when their matters were not ripe for hearing. They hadn't completed discovery, they haven't completed further particulars, they haven't done it, but they got a trial date. We must provide them with a judge, and then these things are not ready. So we set up a court which said we must certify them for trial readiness before they can get a trial date. It's all part and parcel of trying to control the proceedings of the court. When I went into that court, I told him, if you're not ready, there's no purpose for us to reserve a judge for you. We can't do those things. Our courts will. So I'm not even the judge. When I don't certify, I'm not even the judge that hears it. I just simply don't allow you to get a date. And I'm saying you're not going to get a date unless you're ready. So I don't know why they say that. And in terms of work ethic, I don't think this.
That's what I'm more interested in. Are you a lazy judge? Because in essence, that's what they're saying.
Everybody else, in every other comment you have received before you, says the exact opposite. Exact opposite. I have worked extra hours all the time. If there's anyone who can say that with a straight face to me, I would simply say to them they need to rethink.
Thank you, Judge Vally. That's the end of your interview.
Is that the end of my interview?
It is.
Wow, that was quick. Thank you very much, everybody. Thank you for the opportunity. And before I leave, can I just say thank you to Judge President Moemela for giving me the opportunity. Can I also say thank you to Judge President Moemela for giving me the opportunity to act in that court and to experience that court which I'm now applying for. Thank you all for your time, and I wish you all the best in your deliberations.
Thank you, Judge Vally. You're excused.